Good day, Acting Chief Justice Zondo. My name is Sylvester Volane Madala Mangolele, and I appear as counsel for the plaintiff on the matter to be heard in terms of Section 14, 1A of the Superior Courts Act. It is indeed true that all people using the services of court are bound by the rules of court. And in procuring evidence for trial on the 7th of December 2021, I had difficulty in relation to the maladministration by the Office of the Registrar. Notwithstanding the misconduct or maladministration by the Office of the Registrar, I then served the matter to the parties without it being issued in terms of Rule 38(1)A of the Uniform Rules of Court. It is indeed true that as counsel, one cannot derogate from the rules of court in any event. And it is indeed true that no person or organ of state may interfere with the functionings of courts as obligated in terms of Section 1653 of the Constitution. Now, I have sent you, Acting Chief Justice, an email, attached to it the recent administrative function application in terms of Rule 11 of the Uniform Rules for the court to consolidate all matters, as the same question of law would arise if different actions were taken. And subsequent to that, I have issued a subpoena in terms of Form 16 of the Uniform Rules of Court as envisaged in terms of Rule 38(1)A of the Uniform Rules, in which I have called the incumbent President Cyril Ramaphosa, amongst many other persons, including the head of court, Judge President Hlophe, and the Honorable Davis J., as the person who has made the order that is in question. The reality in this particular matter is that, in terms of Section 38 of the Constitution, I must enforce the law. And in enforcing the law, all people employed by the law must obey the rules and principles provided for in the Constitution and the law. I am not confused with what is happening. I understand the train of frustrating a person, as now I would be sitting frustrated saying, hey, the President is not going to come and answer in terms of Section 4 of the Constitution. No, the President will come and answer in terms of Section 4 of the Constitution, because the President must uphold, defend, and respect the Constitution as the supreme law of the Republic. I am not fighting with the President. I am not fighting with the Chief Justice when I ask the Chief Justice to, in terms of Section 1656 of the Constitution, read with Section 47 of the Superior Courts Act and Rule 38(1)A, to ensure that all these particular people come to court. I do, however, have a difficulty with my email, because most of the emails in the judiciary are rejecting my email. And then I will show you this one simple example in relation to what is currently happening right now. You see, in this email, all these are judiciary. It's like the server of judiciary has blocked Mangolele. You see, blocked, message blocked, message blocked. Even the normal people that I've always sent messages to, I am blocked. And what happened yesterday is that the registrar of the Honorable Tulara J refused to allow me entry to her office to serve her with the documents that I have served the other parties for the judge to go through the matter. She told me that I must email these things. And as I've emailed it 36 minutes ago, my emails are being rejected. What is emailed in there is you say, "Good day. On 7 December 2021 at 10:00 in terms of Section 14A1 of the Superior Courts Act, case numbers 15141 2018, 19275 2020 and 18063 of 2021 will be heard. The court manager is requested to ensure that there is a projector and audio speakers available in court as there is video evidence that must be presented. The National Anthem affects us all, including our children and their children's children, and it is tried that a child's best interests are of paramount importance in every matter concerning the child. I am the defense force. I serve and defend my country and its people in accordance with the Constitution and the law and with honor, dignity, courage and integrity, without fear, favor or prejudice. The Acting Chief Justice Zondo must, in terms of Section 1656 of the Constitution read with Section 47 of the Superior Courts Act and Rule 38(1) of the Uniform Rules of Court, ensure that all witnesses attend court on 7 December 2021 at 10:00. The Western Cape Registrar arbitrarily or without just cause derogated from the obligations imposed in terms of Rule 38(1)A, which provides that any party desiring the attendance of any person to give evidence at a trial may, as of right, without any prior proceedings whatsoever, sue out from the office of the registrar, not from the office of the judge, not from the office of any other person, but from the register of the registrar, one or more subpoenas for that purpose, each of which subpoenas shall contain the number of and the names of not more than 4 persons and service thereof upon any person therein named shall be affected by the sheriff in the manner prescribed by Rule 4. And the process of subpoenaing such witnesses, if any witness has in position, it shall be as nearly as may be in accordance with Form 16 of the first schedule. If any witness has in his possession or control any deed, instrument, writing or thing which the party requiring his attendance desires to be produced in evidence, the subpoena shall specify such document or thing and require him to produce it to the court at the trial. There is no need for the Acting Chief Justice to have any proceedings whatsoever to sue out the subpoena as explicitly set forth attached herein. The rule is clear in its terms. Any party desiring the attendance of any person to give evidence at a trial may, as of right, without any prior proceedings whatsoever, sue out from the office of the registrar one or more subpoenas for that purpose. The defendants and or respondents must not hide behind the fact that the office of the registrar in the Western Cape High Court is incompetent to sue out one or more subpoenas for the purpose of the national anthem that affects all people in the Republic. And given the reality that the Chief Justice is the head of the judiciary and exercises responsibility over the establishment and monitoring of norms and standards for the exercise of the judicial functions of all courts, and the fact that two of the witnesses are judicial officers, one of which is the head of court, Section 47 of the Superior Courts Act compels the Chief Justice to give consent for Judge President Hlophe and Judge Davis to appear as unwilling but competent and compellable witnesses in this matter. The results of the acting Chief Justice will be self-evident on Tuesday, 7 December 2021, when the incumbent President Cyril Ramaphosa appears to inform all people why are all South Africans subjected to live and struggle, strive or attempt for freedom in South Africa, our land, as he has in all events refused to let all to live and enjoy freedom in the universe, our home. Section 4 of the Constitution imposes an obligation that the national anthem of the Republic is determined by the President by proclamation. It will be very unfair and or unconstitutional not to have the incumbent President on record of court viva voce in relation to the national anthem. Let us not allow a decline in critical capabilities such as the office of the Registrar of the Western Cape High Court to arbitrarily or without just cause deprive all to live and enjoy freedom in the universe, our home. The matter being heard on 7 December 2021 by not more than 3 judges, after being issued in terms of Rule 612A filed with the Registrar on Thursday, 30 December 2020, before noon, to be heard on Tuesday, 5 January at 10:00. Judge President Hlophe is guilty of crimes against the state and the administration of justice. That is why he must be on record to explain why, as head of court, he allowed such misconduct by his court, which include physical fights with security that was told that I must not enter court building, and must account for all the mistreatment I have received as a person. The rest of the details shall be on record of court, which shall be live streamed by all public broadcasters as commanded in terms of the Broadcasting Act. Time has come to make a choice as a nation whether we shall live and struggle, strive or attempt for freedom in South Africa, our land, or we shall live and enjoy freedom in the universe, our home. I have asked the Chief Justice to have a look at this particular video, as you can see it now. Sound the call to come together, and united we shall stand. Let us live and enjoy freedom in the universe, our home. I ask you all to kindly share this with all people, and ask them to share it with all other people, for all to stop living and struggling, striving or attempting for freedom in South Africa, our land. Prayer changes things for all people. God is good all the time. Let us indeed true live and enjoy freedom in the universe, our home. The national anthem affects us all. The administrative part of it is something that will come in the later part as the incumbent fifth president Cyril Ramaphosa refuses to act in terms of section 4 of the constitution and by proclamation change the terms "let us live and strive for freedom in South Africa, our land," and replace it with "let us live and enjoy freedom in the universe, our home." So for each day you see me suffering, know it to be true that all people are being subjected to slavery to live and struggle, or strive or attempt for freedom in South Africa, our land. Fellow people, prayer is the word of God, and God is good all the time. And it is true, without taking you further into that reality. So you will understand that for Tuesday, the Chief Justice will have to ensure that all these particular witnesses are there. And let me show you what I mean in that regard. What I mean in that regard is that we have this particular reality in which I have written this. We are at page 45. The court issued this. It's a Rule 11 application. This particular Rule 11 application reads that take notice that in terms of Rule 10.2 of the Uniform Rules of Court, Sylvester Volane Mangolele joined several causes of action in the same action to be heard on 7 December 2021 at 10:00 and applies to the court to, in terms of Rule 11, consolidate the above actions under the following circumstances. Section 2(1)(b) and C of the Vexatious Proceedings Act is substantially the same question of law or fact which shall be determined by a court consisting of not more than 3 judges as envisaged in terms of Section 14(1)(a) of the Superior Courts Act. The right to relief of all parties depends upon the determination of substantially the same question of law or fact. And if separate actions were instituted, would arise on each action. Since the national anthem affects all people in the Republic, and at section 195(1)(g) of the Constitution imposes an obligation that public administration must be governed by the democratic values and principles enshrined in the Constitution, including the principles that transparency must be fostered by providing the public with timely, accessible and accurate information. The South African Broadcasting Corporation is commanded to, in terms of the object of Broadcasting Act 4 of 1999, live stream the proceedings so as to educate all people in the Republic to say to God in national prayer, "Let us live and enjoy freedom in the universe, our home." At paragraph 10, in the matter between NDPP and Media 24 Limited and others, the Supreme Court of Appeal held that the right of the media to gather and broadcast information, footage and audio recordings flows from Section 16 of the Constitution. The right to freedom of expression is one of a web of mutually supporting rights that holds up the fabric of the constitutional order. The right is not limited to the right to speak, but also to receive information and ideas. The media hold a key position in society. They are not only protected by the right to freedom of expression, but are also the key facilitator and guarantor of the right. The media's right to freedom of expression is thus not just or even primarily for the benefit of the media. It is for the benefit of the public. In Khumalo versus Holomisa, the Constitutional Court emphasized, in a democratic society, then, the mass media play a role of undeniable importance. They bear an obligation to provide citizens both with information and with a platform for the exchange of ideas, which is crucial to the development of a democratic culture. As primary agents of the administration of dissemination of information and ideas, they are inevitably extremely powerful institutions in a democracy, and they have a constitutional duty to act with vigor, courage, integrity, and responsibility. Section 21B and C of the Vexatious Proceedings Act is unlawfully and intentionally misrepresented since 14 September 2018 to date to cause the plaintiff harm or potential prejudice in that the Minister of Defense owes the plaintiff more than 15 billion. The South African Human Rights Commission owes the plaintiff more than 50 million. The South African Broadcasting Corporation owes the plaintiff more than 50 million. Cell C Limited owes the plaintiff more than 80 million. Equality means everyone is equal before the law and has the right to equal protection and benefit of the law. Equality includes the full and equal enjoyment of all rights and freedoms. To promote the achievement of equality, legislative and other measures designed to protect or advance persons or categories of persons disadvantaged by unfair discrimination may be taken. The state may not unfairly discriminate directly or indirectly against anyone on one or more grounds, including race, gender, sex, pregnancy, marital status, ethnic or social origin, color, sexual orientation, age, disability, religion, conscience, belief, culture, language, and birth. No person may be unfairly discriminated directly or indirectly against anyone on one or more grounds in terms of subsection 3. National legislation must be enacted to prevent or prohibit unfair discrimination. Discrimination on one or more of the grounds listed in subsection 3 is unfair unless it is established that the discrimination is fair. To the registrar, kindly set down the matter in accordance with the above information. And in that, the State Attorney has received this matter, the South African Human Rights Commission has received this matter, the SABC has received the command, Cell C has received this matter. Good people, my money must come home. Now, in a subpoena to the sheriff and his deputy, inform Matamela Cyril Ramaphosa, who is a black adult male holding the title of the President of the Republic of South Africa as head of the National Executive and is Commander-in-Chief of the Defense Force, with a business address as known by the State Attorney and hereinafter called the second defendant. Inform Thandi Modise and Nosiviwe Mapisa Ngakula, who are black adult females, currently and previously, respectively, holding the title of Minister of Defense and Military Veterans with a business address as known by the State Attorney, hereinafter called the third defendant. Inform Bheki Cele, who is a black adult male holding the title of Minister of Police with a business address as known by the State Attorney and hereinafter called the seventh defendant, that each of them is hereby required to appear in person before this court at Tuesday on the 7th day of December 2021 at 10:00 in the forenoon, and thereafter to remain in attendance until excused by the said court in order to testify on behalf of the above named plaintiff in regard to all matters within his or her knowledge relating to an action now pending in the said court, and wherein the plaintiff claims relief sought in the notice of motion, which inter alia includes the replacement of the terms "let us live and strive for freedom in South Africa, our land," with the terms "let us live and enjoy freedom in the universe, our home." The national anthem in the national anthem of the Republic. A declaration of that the plaintiff is not since 8 August 2018 convicted in terms of Section 105 of the Defence Act 42 of 2002 to imprisonment for a period not exceeding 5 years as unlawfully and intentionally misrepresented in the DoD PESOL system, to cause actual or potential prejudice for the past 38 months in which the plaintiff is without payment of his salary. A declaration that the plaintiff was not heard or given an opportunity of being heard on 14 September as obligated in terms of Section 21B of the Vexatious Proceedings Act, and a rescission in terms of Section 21C thereof, and declaring the obligation imposed by the South African Defence Review 2014 and compel the first defendant to arrest the decline in critical capabilities through immediate directed interventions by sending other defendants to jail for life upon conviction of torture, and inform him or her that he or she is further required to bring with him or her and to produce to the said court all documentation in relation to the plaintiff's alleged administrative discharge from the South African National Defence Force, and inform each of the said persons further that he or she should on no account neglect to comply with this subpoena, as he or she may thereby render him or herself liable to a fine of 300 rand or to imprisonment for 3 months. The registrar refused to sign this particular matter. However, it was served to the parties, and the parties have received the matter as it is. The second subpoena, remember, on a subpoena you can only call out 4 people, not more than 4 people. The next one is Musiwa Samuel Hlongwane, who is a black adult male holding the title of Chief of the South African Navy with a business address known by the State Attorney and hereinafter called the 4th defendant. Colonel Mandela, who is a black adult male holding the title of Officer in Charge, Lexato, Cape Town, with a business address known by the State Attorney and hereinafter called the 5th defendant. Mr. Marcel de Wet, who is an adult male whose race is unknown to the plaintiff and is the person who unlawfully and intentionally made a misrepresentation that causes actual or potential prejudice in relation to non-payment of the plaintiff's salary, with a business address known by the State Attorney and hereinafter called the 6th defendant. Tsidiso Tipanye, who is a black adult male holding the title of Chief Executive Officer entrusted with the implementation of the organizational strategy of the South African Human Rights Commission, with a business address 132 Adderley Street, Cape Town City Centre, and hereinafter called the 2nd respondent, and that each of them is hereby required to appear before court on Tuesday. It is the same thing for the same prayers. The only different is the names of the people. Madoda Mqwakwe, who is a black adult male holding title group of chief executive officer entrusted to supply broadcasting and information services and services that are ancillary thereto to the general public in the Republic of South Africa and beyond its borders to achieve the objectives set out in the Broadcasting Act of 1999. In accordance with the objects set out in the Independent Broadcasting Authorities Act of 153 of 1993, with a business address 209 Beach Road, Sea Point, Cape Town, and hereinafter called the third defendant. Mr. Yaya John Matlaiki Setlope, who is a black adult male holding the title of Judge President of the Western Cape Division, who on 26 October 2021 acted in a willful or grossly negligent conduct that is incompatible with or unbecoming the holding of judicial office, including any conduct that is prejudicial to the independence, impartiality, dignity, accessibility, efficiency, or effectiveness of the courts, to arbitrarily or without just cause deprive the plaintiff access to court while on duty as an agent judge, with a business address, High Court of South Africa, Western Cape Division, Kierom Street, Cape Town. Dennis Davis, who is a white adult male holding the title as a judicial officer who unlawfully and intentionally made a misrepresentation on 14 September 2018 that causes actual or potential prejudice to the plaintiff, with a business address, High Court of South Africa, Western Cape Division, Kierom Street, Cape Town. And it also says the same thing. And subsequent to that, I have written a notice issuing subpoena in civil proceedings against the judge. I have said, in terms of Section 47 of the Superior Courts Act, the Chief Justice of the Republic of South Africa is directed to give consent for the head of court, Judge President Hlophe, and the Judge of a Superior Court, the Honorable Davis J., to appear in civil action before a full bench on 7 December 2021 at 10:00 in order to testify on behalf of the above-named plaintiff in regard to all matters within his knowledge relating to an action now pending in the said court, and wherein the plaintiff claims the relief sought in the notice of motion, which inter alia includes the replacement of the terms So you get that particular part, that one has followed the rules. And then here it was issued yesterday when I went to collect these things. And to the registrar, take notice that the Honorable Mr. Daniel Mafele Utular J. ordered a trial date for the matter to be heard on Tuesday, 7 December 2021 at 10:00. And in terms of Rule 38(1)(a), Sylvester Volani Mangolele hereinafter called, the plaintiff desires the attendance of all persons as sued out from the office of the registrar as nearly as may be, in accordance with Form 16 of the first schedule of the Uniform Rules of Court. And Rule 38(1)(a), you have read it as it is, and counsel commands the office of the registrar not to derogate from this rule and issue the subpoena as directed. There is no need to call any meeting with any judge or any party for the office of the registrar to simply act in accordance with this rule, and in any event, no person or organ of state may interfere with the functioning of the courts. So this was also received, and then the Judicial Conduct Committee on 22 November for inquiry Kutlwano Moretwe sent me an email with reference JSC 950 of 21, complaint against Judge Davis of the Western Cape Division of the High Court. The Judicial Service Commission hereby acknowledges receipt of your complaint. Your complaint will be forwarded to the Judicial Conduct Committee for consideration. The Secretariat will notify you of the outcome of your complaint in due course. Yours sincerely. And then these people have got it, and then I've got it, and then this was entered as page 268 of the record. Now, you will understand the reality that I have done everything in accordance with the rules. And on Tuesday, we expect the matter to be broadcasted live. And we expect the law to be upheld. I expect all of you to be in court if and when possible, so that you can hear for yourself what is happening. And until we speak again, in this regard, God continue to bless you. Be blessed, enjoy, and be thankful. Let us live and enjoy freedom in the universe, our home. Teach your children, teach your friends, teach your grandmother, teach your grandfather, teach your uncle, teach your aunt, teach everybody to say to God, let us live and enjoy freedom in the universe, our home. Papa, O Teng.